See how things drop. All right, everyone. Well, thank you everyone for joining. I'm Scott with the Central Florida ASTA chapter. Along with me is Tom from Thomas Carpenter Law. Today is our first of many webinars that we're going to be hosting this year and beyond. The overall goal is an educational session and then a supplier spotlight each month. So this month's educational session is about the law and everything we need to know about it in terms of being travel advisors. Just a couple of housekeeping things. Because this is a webinar, we are limited to just the panelists speaking. But if you have any questions, and I encourage plenty of them, please open up that Q&A that you see at the bottom of the screen and add any questions. If there's anything that you need us to slow down and repeat, there's also the raise hand feature where we can ask for your feedback live. But I want to go ahead and kick this off so we have plenty of time for questions at the end. Thomas, you want to go ahead and get started?
Absolutely. Thanks so much, Scott, for the warm introduction. And I'm looking at the participant list and I see lots of familiar names there. In fact, some of you I already represent, some of you, but it's always a pleasure to I think my screen sharing is disabled, Scott, so you might need to enact that for me, but or enable that for me rather. Those of you who know me know that I am very passionate in my support for ASTA. And it's always a pleasure to speak to an ASTA chapter. And here we go. So I'm going to just share my screen. And basically, we framed this up as, here are the legal things you need to know. But really, this is about managing legal risk. And so you may have seen some pieces of this in other places. I'm going to talk about it a little bit differently now in light of some of the things that are happening in the industry, but that's where you can find me if you need to reach out to me. That's my contact information. A couple of things to just get out of the way quickly. The first is that this might be viewed as attorney advertising by the states where I'm licensed for informational purposes only, and meaning I'm not intending to give specific legal advice to any of you about any particular situation that you have. Happy to talk about things broadly, but by participating in this webinar, we're not creating any kind of attorney-client relationship, and prior outcomes don't guarantee future results. As in law, so as it is in life. Just a little bit about me. I've been practicing law for quite some time because I'm super old. Most of my clients are in the arts, entertainment, media, and travel industries. I used to work in the entertainment industry, working for SAG-AFTRA and for Actors Equity Association, running the legal departments there and the legislative programs. I'm admitted to state bars of New York and Illinois, but federal courts across the country, including the U.S. Supreme Court. I have clients in almost every country, or in every state. And in addition to my law practice, I also own a travel agency. So my travel business is also part of what I do. So. Let me just see here. Okay, so if you've seen other webinars that I've done, you've probably seen a version of this slide before. But those of you who've been doing this for a long time probably already know that travel has a lot of risk attached to it. There's fraud, there are scams. When you're handling client payment information, chargebacks are a huge problem right now. When clients are traveling, all sorts of things can go sideways, from the pandemics and quarantines we were dealing with a couple of years ago, to terror threats, civil unrest, natural disasters, extreme weather events are happening more and more frequently. But also supplier defaults and bankruptcies, and not just because of the pandemic. We had a few of those, but even before the pandemic, there were suppliers that went out of business. Airlines go out more frequently than you would expect. And then travel is also a highly regulated industry, meaning we are subject to complying with all sorts of regulations at the Department of Transportation, state laws, things like that. So even though all of those touch points for risk can be kind of scary, these are not problems that have no solution. You can fix these problems. And so this is, these are some of the key ways that I recommend that people manage legal risk when you're running your travel business or when you're booking travel for your clients. The first is have the proper organizational form for your business. Second is have your own E&O insurance, and we're going to be talking in more depth about all of these things. Well-crafted documents and policies. That's the main part of what I think is really important. Using a good tech tool and implementing that as part of your workflow. And especially, and this is the one that people argue with me about, and I don't know why, but following best practices when collecting payment information and getting credit card authorizations. So let's just start with the best form for your business. There are 3 principal ways that you can organize your business legally. First is as a sole proprietorship. Second is as a corporation or as a limited liability company. So if you're a sole proprietor, basically you and your business are one and the same, which means that you're taxed as an individual, but the liabilities of your business are also your personal liabilities. So if your business gets sued and you're a sole proprietor, there's really nothing to protect you, your personal assets, your house, your car, your savings account, your retirement. That is all potentially subject to liabilities that your business incurs. If you're a corporation, you do have protection of your personal assets from liability, but you're taxed twice. You're taxed as a corporate entity and then also as an individual. And so the sweet spot for most travel businesses is forming an LLC or a limited liability company, because you've got a lot of flexibility there. You can be taxed as an individual, or it's somewhat uncommon. You can't take an LLC and tax it as a corporation. Most people don't do that, but there are a few. I represent a couple of those companies. But your personal assets are protected from the liabilities of your business. So that is the sweet spot. One thing, and I'm not going to talk a lot about independent contractors and working with ICs, but I am finding people who are functioning as a sole proprietor who are bringing on independent contractors. And I think, I'm going to express an opinion here, I think that's a huge, huge mistake. If you're going to be bringing on independent contractors, there are all sorts of potentials for liability. If you misclassify an employee as an independent contractor, you could be liable. I have a client in another state who had an IC that filed an unemployment claim with the state of New Jersey, and that agency is now liable for tens and tens of thousands of dollars in fines because of that one misclassification error. And if she had not been an LLC, she would have to pay for that out of pocket, even if her business couldn't absorb it, if her business can't absorb it. So just one example of why it's really important, especially if you're working with independent contractors, to either form a corporation or an LLC, because you don't want to, if you get it wrong and the IRS or the Department of Labor comes after you, you don't want to be dealing with that and have your personal assets be at risk. Errors and omissions insurance. It is important for everybody to have this in place. I hope everybody does. Your errors and omissions insurance is there to protect you if you make a mistake, and everybody makes mistakes. We all, simple human error just happens. If you are a hosted advisor, your host agency might cover you for errors and omissions, but even if they do, I would strongly recommend that you get your own policy, because if one of the other advisors in your host agency files a claim, that could eat up all the coverage limitations. There might not be a whole lot left for you. You might need to add your host agency to your policy as an additional insured party. Nothing nefarious about that. It's just to make sure that you're both protected. You want your host agency to be protected. And I would just, generally say that $1 million in coverage in E&O is what I would recommend. At least $1 million in coverage for even the smallest businesses. I don't think the difference, the last time I had somebody look at it, there was not a huge difference between 500,000 in coverage and $1 million in terms of the cost. So just get the E&O and policy in place. One other thing, and this is something that's relatively new that's been happening lately, is E&O insurers are taking a position that if you book a lot of FIT trips, or if you take net rates and mark them up, or if you do any number of other things, that makes you a tour operator. And tour operator E&O policies are much more expensive. But if you've got E&O currently, I would recommend calling your insurance company and talk to them about what you're doing, what types of trips you're booking, and just confirm that you've got the right policy in place. Make sure that you've got a rider for mistakes in offering insurance, that type of thing. Those things are cropping up here and there, and you wouldn't want to file a claim only to find out that your E&O insurer is taking the position that you're a tour operator and you aren't covered for that. So, okay, so that kind of brings us to the documents and policies thing. This is, I would say this is like 90% of what I do for people from day to day. And also, I'm going to apologize because I have two dogs. I should have done this earlier. The two dogs sleeping on the couch behind me, and one of them is a pug, and she snores like an old man. So if you hear snoring, I'm not falling asleep on you. And anyway, getting back to terms and conditions documents. Okay, so a terms and conditions document is a legal document that is really the boilerplate for all of your trips. You want it to be structured as a legal agreement between you and the client, which means you want your client to actually sign on to it in some way. And I have a strong view that you can buy policies out there that are kind of generic and cookie cutter. I have a strong view that those don't really protect you in as well as something that's drafted custom for your business. And I don't say that just because that's what I do. I say that because I've seen some of those policies that are out there that are that you can buy either through a subscription service or as a one-time purchasing the document from somebody. Whenever a client has done that, they've spent hundreds of dollars to get access to a terms and conditions document that not only might not be protecting their business in light of the types of trips they're booking or the types of clients they're working with, but there also might be things in there that really you don't want to have in there. And so pretty much every time that somebody's brought something to me and said, can you look at this and am I okay, I would almost always recommend making edits to that. And in some cases, if the edits are significant, you might as well just start over from scratch. And if anybody wants help with that, more than happy to set up a complimentary consult with you. As an attorney in the ASTA Attorney Referral Program, I do complimentary consults of 15 minutes for any ASTA member. So more than happy to chat with any of you. Okay, so what goes into a terms and conditions document? I break it down into 5 categories, I would say. The first are legally required disclosures. I mentioned earlier that travel is a highly regulated industry. Because it's so regulated, there are all sorts of things that government agencies require you to disclose. For example, when you're selling airline tickets, seller of travel registrations. If you're in Florida, maybe you have your own. If you're working through a host agency, maybe you need to disclose your hosts, but also for if you're selling to California residents, Washington state residents, those are legally required disclosures that you need to make. You need to make them in the right way. California in particular has this like magic language. They have a whole document that shows you how to disclose your seller of travel registration. So it's not as simple as just saying, here's my number. You have to actually jump through all those weird and crazy California hoops. Second category is clarifying your role as a travel agent versus your role as a travel advisor. So as we all know, ASTA rebranded and now we're the American Society of Travel Advisors. Before that, we were travel agents, but really we're actually both. So the agent part of being a travel agent is that you are the booking agent for suppliers, meaning you have a duty, a fiduciary duty to the suppliers that you sell. You can't undercut their pricing unless you're Costco. You can't misrepresent their product. So you owe a duty of care to the suppliers that you're booking, but you also have a legal duty of care to your clients, and that's the travel advisor role. So being in that middle zone where you are both a booking agent of the supplier and you are a travel advisor to your client, that is a complicated place to be, because you have duties, legal obligations and duties that flow in both directions. So in your terms and conditions document, I put a lot of provisions in there where your client is acknowledging what your role is, even if they don't understand it intuitively. And I think we've all booked travel for clients that don't understand how we work. They think we book travel the way they do. They don't realize that we are wizards and they are muggles. And so, you know, they don't understand that. So you can have them agree that they understand that as part of the terms and conditions document. Advisories to clients. There are all sorts of things that courts have said over the years that we're supposed to advise clients. Like you wouldn't think that you would have to tell somebody they need a passport to travel, and yet they do. And somebody showed up at the airport and didn't have a passport and then sued their travel agent because you never told me I needed a passport. And it's, you know, it might seem obvious, it might seem stupid, but we have to do those things. You can take care of that in your terms and conditions document. Risks and safety, advisories that people need vaccines, whether that's a COVID vaccine, a yellow fever vaccine, a typhoid vaccine, advising them that if they have criminal convictions that they might not be able to travel to certain countries. All of those advisories you can put in a terms and conditions document to make sure you've got your bases covered on that. I think the most important part of any terms and conditions document are the disclaimers of responsibility and liability. So those are basically where those provisions are provisions where you're telling your clients that because you are the booking agent and not the supplier, that you are not responsible for anything your supplier does or fails to do that leads to damages or injury or loss. So most of those things you're not going to have control over. So if somebody breaks into your client's room and steals their jewelry, you don't control the security at the resort. If somebody complains that there's seaweed on the beach and their destination wedding smelled horrible and they blame you, not your job to clean up the beach. So none of those things are your responsibility, and your clients can agree in your terms and conditions document that they cannot and will not be able to hold you responsible for those things. So I think we all know that, recall last summer, the travel advisor who got sued because her client wandered, got blind drunk, wandered off the resort property and stuffed himself in a window and died at the property next door. Obviously, what that travel agent got sued, but obviously the travel advisor has no control over anything that happened at that resort. And so, having a provision like this can really help protect you. Also, limitations on liability that because you're paid based on commission and fees, they try to sue you for $30 million and you only made $700 on the trip. I put a provision in your terms that where your clients are agreeing that even if they do drag you into a lawsuit, they can't recover more from you than whatever you made on the trip. So that's an important provision as well. So the disclaimers of liability and responsibility, that is really, I think, the key to a terms and conditions document. And then we've got force majeure. Force majeure events, this is kind of related to the disclaimers of liability and responsibility, but force majeure, those events are anything that is unforeseen, unpredictable, outside of your control. If those things make it impossible for you to do something you're supposed to do, this is the language that lets you off the hook. So natural disasters, power outages, fires, floods, hurricanes, pandemics and quarantines. If a big storm rips through your community, knocks out your power, you can't make a bunch of payments, that storm is a force majeure event, and your force majeure clause can say that you're not responsible for missing those payments that you couldn't make because it was impossible. Okay. So once you've got your terms and conditions document, what then? As I mentioned earlier, it is a contractual agreement. You need it to be contractual in nature, which means you need your clients to actually sign on to it in some way. And so what I recommend doing, this is what I do in my travel business, it seems to work for other people, is I use a client agreement as sort of a shorter, more user-friendly way to get my clients to sign on to my terms. And I integrate that client agreement into my workflow. So, and the workflow is, there's nothing particularly legal about it, except for the fact that it helps make sure that you're not missing a step and that you are regularly and consistently getting your clients to agree to your terms and conditions, making sure that you send out the insurance quotes, all the things you need to do to protect, other things you need to do to protect yourself from liability. Having a really solid workflow is important. And I spend a lot of time when I do terms and conditions with my clients, spend a lot of time talking to them about their workflow, depending on what technology tools they're using, that sort of thing. So, basically, right after I do an intake call, what I do is I'll say to them, great, I'm going to send you my new client info form, which is really my new client agreement. And the client agreement has a link to my terms and conditions. So I upload my terms and conditions to my website. It lives over there. And after I do my intake call with the client, where do you want to go? What do you want to do? What's your budget? Talk to them about how I work with my clients, mention my fee structure, mention the importance of travel insurance. And then I say, great, I'm going to send you a little form. They get the form. The first thing it says is, check a box. I'm hiring you to plan my trip, and I agree to your terms and conditions, which are located at, and then the link to where they can find it. I have my clients agree to that at the very front end of the relationship as soon as I hang up the phone with them, because that way everything that's in my terms and conditions, all those things that protect me, are part of our relationship going forward. And then I also, to back up that by building in the redundancy in my workflow, I also have them agree to my terms and conditions as part of the credit card authorization. So basically, for a repeat client, if I'm not sending them my new client agreement, they're agreeing to my terms when they make a deposit on their next trip, when they add final payment, if they buy insurance, if they pay my fee, if they add supplemental services, they're agreeing to my terms over and over and over again. I'm protected. They can't say they never agreed to it when they agreed to it 1,100 times. So client agreement, I mentioned this earlier. The client agreement is like the vehicle to get people to agree to your terms and conditions, your fee structure. You can put insurance advisories in there as well, having your clients check a box that acknowledging that you've talked to them about travel insurance, because that's important. And really anything else that's important for your clients. So I have a client does a lot of school trips. They have a box to check. I give permission for my child to travel and agree to the student code of conduct. You can be flexible and adaptable in the client agreement, but basically whether they go to your website and read the terms, that's their responsibility. So here's the language that I use on a new client agreement when I have them check the box on the form that I build out. I'm hiring, name of the agency, to plan my trip, and I agree to the terms and conditions of booking, which are located at, and then the link to where they can find it. And then, oops, I thought I had another. Oops, I guess not. Okay. So here's why you need both. Terms and conditions, that's going to be stable and consistent. The same for every trip you do, groups, FIT, corporate, leisure, whatever it is, your terms and conditions are going to cover you. It is the baseline for everything you do. And because it's the baseline, you're not going to be you're not going to want to poke holes in it. You're going to want to make sure that it's stable and consistent. The client agreement, you can have different client agreements for different clients. Maybe you're not charging fees to friends and family. You can eliminate that box to check on your client agreement. Maybe it's a school group. You can add that thing in there about giving permission to travel. You can be flexible and adaptable. You can reinforce important things. Like I have one client who feels so strongly that it's important for her clients to look at the reservations promptly so that she doesn't get a call on the way to the airport about, oh, I just looked at this, my name's misspelled. And then what's she going to do? They're on the way to the airport at that point. So she puts a box to check on the client agreement in big, bold letters. It is my responsibility within 24 hours, blah, blah, blah. Because she wants her clients to, unlike the terms and conditions where she doesn't want to rub their nose in it, that's something that she wants them to absolutely pay attention to. So again, client agreement, you can be flexible and adaptable. And the other thing that I like about a client agreement is if you have a box that they check that they're hiring you to plan their trip, and I feel like that kind of creates a mindset that they're working with you now, They're not going to check you on price. They're not going to shop around. They're not just kicking the tires. They checked a box that they're hiring you. So it kind of, I think, makes them feel mentally like they're locked into a relationship, even if they, even if they hem and haw and they're wasting your time. You can fire them at that point and feel good about it. But I think it reduces the likelihood that they're going to try to shop around, basically. Checking a box is more than sufficient to create a legally binding agreement. There is no magic to wet ink on paper. You just need some sort of record in your system of when and how your clients agreed to your terms. So you can print that out and have them sign it wet ink on paper if you want to, but the client agreement, if you're using a tech tool that can store those types of things, if they go to that's going to be sufficient if you can just print out something that here's where they checked it off. Whether they go to your website and actually read your terms and conditions, that's up to them. But when they check the box and return the form, you are good to go. The exception is if they're waiving legal rights. If you have a waiver of a legal right, that's something that you can't do by checking a box and returning a form. Those require signatures. And so that's why when people say to me, I want to put something in my terms and conditions that says that I have the right to use my client's vacation photos in my marketing or on my website or on my social media feed. Well, people have a right. It's called a right of publicity. It's a state law right. They have a right not to have their images used for commercial advertising. And so if you're putting that in your terms and conditions and you intend to rely on enforcing it that way, you're going to need them to actually sign your terms and conditions. It doesn't have to be wet ink on paper. It could be digitally, but you're going to need a signature for that. So I try to keep those things out of the terms and conditions document. As far as using people's vacation photos, just ask them. Most of the time they'll say yes, but if they don't like the way they look in the picture and they say no, of course you're not going to use it. I mean, you're not going to destroy a relationship with a client, and people appreciate being asked, right? So don't rely on a terms document for something like that. Have the conversation. When you send a quote, this is one thing that you can't do in your terms and conditions. So this is something to put into your workflow. When you're sending quotes, you have to disclose who the supplier is. Courts require that, but it also protects you because you're not required to send the supplier's terms and conditions to your client. There are court cases out there that are pretty good on this that say you don't have to do that. But in your terms and conditions, if it says that they're automatically agreeing to whatever the supplier terms are, then they've agreed to those supplier terms. Maybe you don't know at the time they're signing it who that supplier is. Disclose it in a quote, drop it in a footnote, or put it on the invoice. I booked this through Classic Vacations, or this tour is being operated by G Adventures, whatever it is. They might not understand your role as the booking agent, but if you've disclosed who the supplier is, they will be obligated to those terms if you've got that in your terms and conditions. Tech tool, I am a huge proponent of having people use technology that works for them. In my travel business, I use TravelJoy for my CRM functions, and I use Travify for itinerary planning. But either TravelJoy or Travify will allow you to create customized forms. Vacation CRM does a lot of the same things. There are even some non-travel specific tools that are out there that you can use. I know a lot of people are using Test because their host agencies provide them that. I'm not a fan of Test, frankly, because it doesn't allow you to customize it the way I think you need to in order to really protect yourself, but it's better than nothing. And there may be ways to do a workaround. I'm just not familiar with the Test structure to be able to do that. But at any rate, what you need a tech tool to do, you need it to allow you to create custom forms. You need to be able to transmit credit card numbers securely. It's helpful, I think, if it has some sort of e-signature function for the things where you do need a signature. And it needs to be able to keep a record of when your clients submit the forms and sign the documents. So whether that's an invoice, whether that's your client agreement, whether that's an information form, you're going to want a record of all of that you can rely on and pull up later. Okay, this is what people are arguing with me all over the place about. They take a credit card number, And then the client says, oh, just charge my card that you have on file. That is a horrible idea, because credit card chargebacks are a real big problem. They are increasingly difficult to resolve, and the credit card companies are going to require you to, if you do have a chargeback, they're going to require you, or the supplier, they're going to require you to get an authorization every time that you process a transaction. You're going to need to show the date that it was authorized, the amount being authorized, and what it was that they were paying for. Do not take numbers by email or text. Please, please, please don't do that. Avoid taking them over the phone if you absolutely can. If you can avoid that, just don't do it. Definitely don't do just charge my card you have on file. And when you're storing those numbers, please don't put it in an unencrypted system. An Excel spreadsheet is not going to work for you. You want this to be encrypted, because if somebody gets access to your spreadsheet or your database and they hack into that, you're going to be in a world of hurt, and it's really, really expensive to protect your business from a data breach. Your insurance is probably not going to cover you for that. You're going to have to do a lot to comply. It's a mess. And so I've had to do that for clients of mine. Just trust me, you don't want to deal with it. Okay, so on the subject of chargebacks, during COVID, the credit card companies changed the standard for how they resolve chargeback disputes, which would be known as pulling the rug out from under you in any other context, but because they're credit card companies, they get to do whatever they want. So there's a new standard for credit card authorizations. And so right now, in order to win a chargeback dispute, you are going to have to prove that the client agreed to your terms and conditions, prove that your client terms and conditions included a cancellation and refund policy. And this is the new thing. Now you're going to have to also prove that the cancellation and refund policy was brought to the client's attention at the specific time that the charge was authorized. That's new. And that's where most people got dinged when they lost chargeback disputes. So I would recommend using language like this for your credit card authorization. I'm authorizing the name of your agency to charge my card referenced above in the amount indicated. And I agree to the terms and conditions of booking, including the suppliers and refunds, suppliers and agencies cancellation and refund policies, which are located at this link. So that's language that's going to, check that additional box. It's a little bit more than probably most of you are using, but that'll help you. Just one little thing about chargebacks. I think a lot of times when people dispute a credit card charge, they think that they're getting their money back from the credit card company. They don't realize that what they're doing is they're reporting it to the bank as a fraudulent charge. And so even if you're not processing the payment yourself, you're not taking the payment, it's not running through your accounts. If you're using your client's credit card to make a payment directly with the supplier, a cruise line, an airline, a tour operator, a hotel, a resort, if you're using their card number to make those payments and they report it as a fraudulent charge, it's kind of like they're accusing you of credit card fraud. And so there are scenarios where the supplier could come after you for the amount of that disputed charge to try to recover that from you. And so to avoid getting stuck on the hook for that, having credit card authorizations that you can pull out, that you can show to the supplier, or you can show to the credit card company, showing that, yes, I had authorization to make this charge, that's going to help you. But I would also recommend having a provision in your terms and conditions document that says that your client's not going to do a chargeback. If they've authorized you to make a payment, that they're not going to do a chargeback. And if they do, and you're damaged, that you can recover that money from your client. So terms and conditions, again, really important. Okay. Key takeaways: choose the right form of your business. For most of you, I think that's probably going to be a limited liability company. If you need help with that, let me know. We do them in all 50 states. We can do them in Florida for you. We use a service to make sure it's done correctly. You could also use a local attorney if you wanted to. Get your own errors and omissions. Oh, and again, if you're working with independent contractors, please, please, please don't be a sole proprietor. You are flirting with disaster. Get your own errors and omissions insurance. If you don't have your own E&O insurance, make the investment. Find out whether you're a tour operator, and to make sure that you've got, in the eyes of your insurance company, find out whether you're a tour operator. Even if you're not a tour operator, find out whether they think you're a tour operator, and make sure you've got the right policy in place. Have really, really solid documents in your business, like a terms and conditions document and a client agreement. Have a really good workflow. Use tech tools, become familiar with them, make those tech tools part of your workflow, and then get a credit card authorization for each and every charge. And even if your clients don't like it and say, why can't you just take it over the phone? You did it last year. It's a new day and age. And let me go back, actually, because this is an important story. So I had a client who booked travel for his best friend, actually. And his best friend took the trip, had a miserable time, came back and said to his friend, who was running a small travel business, that trip was awful. It sucked. I'm not going to pay for it. I shouldn't have to pay for it. Everything was horrible. The room was dirty, all the complaints, right? And my client said, and said, well, you took the trip and it's non-refundable, and I'm sorry, but I can't get your money back at this point. I'll try to follow up with the resort to see what they'll do. The problem was he didn't have a credit card authorization, and so when his best friend did a chargeback, because his best friend thought, I shouldn't have to pay for that vacation, the credit card company approved the chargeback, and my client had to pay I think it was like $15,000 for his best friend's vacation. And he begged his best friend not to do it. He told his best friend, that's going to come out of my pocket. His friend didn't care. His friend was so upset about what happened on the vacation that did the chargeback anyway. And so now my client had to pay for, $15,000 of his client's vacation, plus he lost his best friend. So if he had had a credit card authorization, he could have provided that to the supplier to get out from under that. So again, get the credit card authorization. Okay, so this is me. This is where you can find me if you need me, and I am more than happy to take whatever questions you might have. So, and I'm going to just stop sharing unless people need me to. This is being recorded, right, Scott? So
yes, it is. So if there's anything that you want to go back and rewatch later on, feel free. We'll figure out how to distribute it this week to everybody. Now there is the Q&A option at the bottom of the screen. Feel free to put in any questions that you have in there, or you can jump in the chat. I think it's visible for you. If not, add it to the Q&A and we can chat that way too. A couple of things that have popped up, plus a few of my questions. So just to kind of stress the need of an IC's own E&O policy. Why is that so important?
I'm sorry, say that again.
So you said that an independent contractor should have their own E&O policy on top of the host agency's policy. Why is that important?
Right. So if you are covered by your host agency's errors and omissions policy, a couple of things about that. First is it's probably has a really, really high deductible, meaning you're going to have to pay for most of it before you can even get to the part that's covered by a claim. But in addition to that, you're sharing that policy with however many agents are also covered under your host agency's policy. So, if it's a relatively small host agency, maybe that's not an issue. But if you are with a large host agency that has thousands of businesses that they're hosting, if one of those other agencies files a claim under the host agency's errors and omissions policy, all of these policies have limitations on coverage and caps on how much they'll pay out. If somebody else eats up all of those limitations, there might not be a whole lot left for you. So having your own policy is a really good idea. And there was a question in the Q&A about the email address. I typed in my email address there so that people can shoot me a note if you want to.
Excellent. Thank you. And then I had a follow-up for myself on that, but I forgot what it was. Now, if an LLC lapses, so like you don't pay your state's annual fee and it lapses, does that default to sole prop, or does something else happen?
I mean, it really depends on it depends on state by state. So different states have different requirements. So I'm in New York, and like just because you're in Florida doesn't mean you have to be a Florida LLC to operate in Florida, right? You can be incorporated in Delaware as an LLC or in Nevada or wherever. So like in a state like New York, there are no ongoing filing requirements. It is, however, really expensive to get your initial LLC in New York because you have to publish it in a newspaper, which means you have to spend, $1,000 to, depending on which county you're in. Anyway, that's a neither here nor there. Other states that have annual filing requirements, how the state handles that is going to just depend on it's just going to depend on what the laws are and how they're administered in that state. So and I'm not intimately familiar with how Florida handles that, so I'm not the best person to ask right now, but my paralegal who does LLCs for people can could certainly get you that information if you're concerned about it.
Excellent, thank you. And Stephanie's asking if planning a trip with multiple people and only one's paying for everything, do they both need to sign the claimant agreement?
Well, if you can get them to both sign the agreement, that's great. But I draft terms and conditions documents with a provision that says that if the person who agrees to your terms and conditions is taking responsibility for all of the bookings they're making for other people in the traveling party. So like if you've got a multi-gen family group, and you're talking to grandma and grandpa, and then the daughter-in-law calls you up and says, I'm not paying for this trip. And well, go back to grandma and grandpa and hold them accountable for it, right? But for larger groups, like things like destination weddings, you might be dealing with just the bride and the groom or one of the families. If they're making reservations for a bunch of other people, you can hold them accountable, but also you could have them agree to your terms and conditions as part of like a shorter version of your client agreement. So like if you've got like maybe just a booking form that says, here's the information I need to book you into the group, name, address, date of birth, telephone number, email, sign up for my mailing list, check I agree to your terms and conditions of booking, and they have to check that before they can book into the group. So you can, that's why I say that client agreements can be really flexible and adaptable. So you can you could have them do it that way. So it just depends on the trip and the group and what they're doing.
Excellent, thank you. And we also have a question from Kathy. Is an email from a client agreeing to charge a particular item considered a credit card authorization?
Yeah, so if you have an email that checks all of those boxes of the things that I was saying earlier, I mean, you could send them an email that says, if you've got somebody if you're not using a tech tool, I think this is a little bit clunky, but it might work. Ultimately, it's going to be the decision of the credit card company whether they accept your authorization as valid, right? And so you don't have a lot of control over that. Even when people have credit card authorizations, they still lose these disputes because they didn't have people acknowledge the terms and conditions. They didn't have people acknowledge they didn't call the attention of the client to the cancellation and refund policy at the time that they agreed to the terms and conditions, at the time that they were authorizing the payment. So you could send, I guess you could send somebody an email saying, I'm happy to put this final payment through. Just reply to this email that you're authorizing me to charge your card ending in 4567 in the amount of $1,258.67. and that you agree to my terms and conditions of booking, which are at this link, including the cancellation and refund policies. And then reply to this email that all of that is correct. And then, then you've got a piece of paper that you can show somebody. Hopefully that would work. But really, ultimately, whether that happens, whether that is acceptable is just going to depend on what the credit card company or what the supplier does with it. So a lot of times, increasingly, I think because I booked with a supplier. I booked something with a supplier today. I hadn't booked with that supplier in a while, and they're now sending out payment links directly to the client so that the client can do that. And I think the reason they're doing that is because a lot of travel advisors cut corners when it comes to getting credit card authorizations. And so the suppliers are on the hook for those chargebacks. Sometimes they send those to recovery, sometimes they don't, but having a tech tool, I think, is really going to be your best, most, if you can find a tech tool that you can work with that will get you a secure credit card information, that I think is going to be easy for most people. People are used to checking a box and returning a form, but if your clients won't do that, then it's a little more complicated, I guess.
Yeah. We have a question for seller travel states that also requires IC to have their own license. If you bring that IC on, are you legally required to verify all their information, or does the IC just need to sign and agree that they are fully up to date and properly licensed and registered?
So the only seller of travel state that requires ICs of the seller of travel to be licensed is Florida, which is I'm assuming why this is coming up. If you have a Florida seller of travel registration, your ICs are supposed to get that little TI number. There are lots of people who just ignore that and never have a problem. But since you're in Florida, my recommendation would be that you do what you can. If you are based in Florida, my recommendation would be do what you can do to verify that, so that if there is an issue, you've done your due diligence to make sure that the ICs have taken the steps to register themselves. But the responsibility for getting that TI number ultimately lies with the IC. So my recommendation is, if you're taking this seriously and you want to be a Boy Scout or a Girl Scout about it, to do the verification, and if they haven't done it, then cut them loose.
Excellent. And from Clara, on groups, are you referring to contracted groups as in weddings, corporate getaways, etc.?
It depends. It just depends. So different groups have different requirements. So if it's a multi-gen family group, if it's a block of rooms for guests to a wedding, if it's a come with me trip where you find an itinerary you really like and you take out the group space and market the heck out of it, saying, hey, everybody, we're going to Egypt. Well, great. Those are all very, very different. Whether you need a contract with the group leader is going to depend on the nature of the group. For a come with me trip, you're kind of acting as your own Pied Piper. If you're working with the owner of a yoga studio to do a wellness trip, or a sommelier to do a wine excursion, a wine river cruise or something like that, in those cases, you're probably going to want to have a contract with the group leader to talk about how you're allocating the marketing expenses, to talk about whether there's any revenue or profit sharing, if you're splitting commission with them, or if you're giving them a referral fee for every person they bring on the trip, you're going to want to have that in a contract. So different groups are different, have different components. And as far as getting the clients to agree to the terms on any of these groups, if you have a booking form where the client is giving you their information in order to book into the group, you can have them check a box on a form, and that should be sufficient.
So one question that I came up with, how do you handle clients that book directly with the supplier via like a My Booking link or the Let's Go Book link that Virgin offers?
Yeah, so if that's the case, then you aren't going to have a credit card authorization because you didn't process the payment, right? You've got a link and the client is going in there and putting it in there, so you're out of it. So I actually think I've had a couple of people reach out to me saying, this is horrible. I can't, they're paying the supplier directly. And I'm like, actually, it's not so horrible, because it means they can't come after you for not having authorization. You sent the link to the client paid it. You're out of, you're not on the hook to provide a credit card authorization at that point. So I actually think that's kind of a good way to do it if you can. So, and I'm sure you've all had this issue too, where your clients don't understand. Like when I send an invoice in TravelJoy, they pay the invoice. They think that that's running a charge on their card. And I have to explain to that. And they're like, well, I paid that. I'm like, you didn't pay it. You sent the card number to me so that I could pay it. You just authorized it. And then, it's just like, people don't understand, right? They don't, they're, like I said, we're wizards, they're muggles. They don't get it. So
yeah. Now, how about it from the terms and conditions standpoint? Would we still want to have them sign after they do their own booking, or?
Well, I mean, I think it's a good idea to, that's one of the reasons why I have them agree to my terms and conditions right at the front end of the relationship. So that, if there's something that it's all about building in duplication, right? So they agree to my terms. The minute I hang up the phone with them, I send them my new client agreement. They agree to them there. They agree to them when they pay my fee through the credit card authorization. They agree to them when they make a deposit on their trip, when they buy insurance, when they add supplemental services, when they make final payments. So they're agreeing to my terms over and over and over again. But if one of those payments is something that they're paying directly through a payment link, it's it's just one time out of the many times that I'm working with them that they're not agreeing to my terms through the credit card authorization, but they've agreed to it 4 or 5 other times, so it's still covered. So
yeah, like Clara's chiming in that she likes the direct payment links as well. They work really well, and especially because you don't have to worry about the credit card authorizations. It's just when people randomly find the link online and book a trip overnight that you're like, oh, I guess I got to circle back and here's my terms and conditions just for working with me, but don't worry about anything else.
Yeah, well, and hopefully you're getting notification when they do that, because I've been sitting around thinking, oh, they haven't made final payment yet, and then I call the supplier and they're like, oh no, they paid it, and I'm like, well, I didn't invoice that to my host agency, and so now I'm gonna have to pay a late invoice fee. So thanks, supplier partner, for not helping me out with that. But yeah,
absolutely. Well, so we have a few minutes left. If anybody has any other questions about anything we talked about, feel free to drop them in. We've had a lot of great questions already. Just as a little filler here, I did use Tom's service to build out my terms and conditions, and I had originally had a lawyer look at it and help me write it out. And Tom filled in a lot of blanks that weren't in there. So having somebody that knows our industry do our terms is gold for protecting ourselves. And like one of the little tidbits that no one ever thought about from the legal standpoint was the pesticide notice for planes. So something like that needs to be in there. And I didn't even know that pesticides were a problem on planes until I saw the draft that Tom sent me. So it's good to know. We learn something new every day.
Yeah. The DOT requires those things. Even the airline always takes care of it, but the DOT regulations technically say that you're supposed to disclose those things too. So we put it in there so that you can take care of it.
Yep. Well, excellent, everyone. We'll be cognizant of time. I don't see any other questions. Thank you very much, Amy. I appreciate you giving me that feedback. This is just one of many sessions that we're going to be offering. The next one is a supplier spotlight on the 21st, same time, 2 p.m. and it's with Pleasant Holidays. And then next month, we're going to be doing an education session about SEO and everything you need to know about that. Kathy Bell just asked a pop-up question here. Do you have a sample TNC that they can see?
I don't, because I think I mentioned earlier, I do them custom for every business, because every business is different. So, if you do a lot of destination weddings, you'll need different terms than somebody who does a lot of corporate travel. Every business is a little bit different. So I don't provide cookie cutter templates or, out of the box documents for people. I do them custom. I do them on a flat rate because that keeps the cost down for people. And right now my discounted flat rate for ASTA members is a flat rate of $600 that covers drafting a custom terms document for you, giving you a template of a client agreement, talking through your workflow to make sure that everything's implemented in a way that you can work with it, whether you're using TravelJoy and doing it the way I do it, or whether you're doing it some other way. We can talk through all of that. And then any updates that come later on down the road. So it's not a subscription. If there's something that changes in the industry and I update my language, I send that around to other people, to my client list. So I'm representing your business. I'm not just, selling you documents. I'm actually available to you if you need to, if you've got a question about those documents or you need to talk through something. It's a flat rate so that we can spend as much time on it as we need to without making it feel like you're worried about the clock is ticking and you're on an hourly rate. So in terms of how often to update them, it just depends. My goal is to make it as stable and consistent as possible. Obviously with COVID, I changed a lot of things in my terms document. But since then I haven't, I added a couple of new things. I've started adding a couple of new things related to airline tickets because of the disaster that the airlines were last summer with lost bags and seat assignments and all this other stuff. So I've tinkered with that language. It's not major. It's not substantively different. I've just kind of moved things around a little bit. But I take care of, I keep an eye on all of that for my clients. And if there's something that changes in the industry, a new regulation, something like that, my clients hear from me about it, they'll get updated language, but it doesn't happen all that often. Maybe, every once in a blue moon.
Well, thank you so much, Tom. I appreciate all of this, and I look forward to seeing everyone next week at the next session. Thanks, everyone.
Thanks, everybody. Have a good week.